speaking with me, Tarun Nangia. Today we are going to discuss an issue which is so much important for businessmen and promoters in this country. They have sat up and taken note of this judgment of Bombay High Court, and it is in discussion. Why is it in discussion? Because the Bombay High Court has quashed fraud account classification by Canara Bank, as in that case it did not give the promoter an adequate opportunity for hearing, which is a violation of the RBI Master Circular. Why this is important? Why this may impact or may not impact investments in India, and why when you take this sort of an arbitrary decision can spoil the business environment in India. And the court, in this case, the Bombay High Court, rightly so, has quashed the fraud classification, which in a sense instills confidence in the investor in India that the courts will take care of you in case the banks overstep. In a sense, they are brief and act in an arbitrary manner. Let me welcome today Justice Hema Kohli. As we all know, ma'am has served as a judge of the Supreme Court of India, the Chief Justice of Telangana, and we had a lot of opportunity to do shows on her. For the first time, we welcome her on Legally Speaking.
Thank you. Good evening.
And it is indeed a pleasure to have you, ma'am, on the show. And of course, on diverse topics, we will like to have your participation and looking forward to this one. We also welcome Mahesh Agarwal, who is managing partner of Agarwal Law Associates, one of India's leading law firms at the Supreme Court. Also joining us is Ruby Singh Ahuja. She is senior partner with Karanjawala and Company, one of the leading litigating law firms at the Supreme Court. Good to see both of you, and looking forward to your interesting insights and analysis that you bring in, and expert insights because of a lot of litigation that you do on a day-to-day basis that you bring in to the table. At the outset, let me request Mr. Mahesh Agarwal to give an opening comment on this issue, and then we move ahead. Over to you, Mr. Agarwal.
See, this circular served a very salutary purpose. It was very critical for the banks and to safeguard public monies. It is nothing but an alarm system that the banks follow a procedure and they are alerted that there is some kind of a siphoning off, some kind of a wrong done, on the basis of which there is a red flag and they can declare an account as fraud. But that's not all. What happens is that once an account is declared fraud, several consequences follow, both civil and criminal and corporate consequences. Civil consequences are immediately your lending is stopped. There is virtually a civil death followed by a spate of criminal cases. So the issue was that if any decision of a bank results in such civil and criminal consequences, there has to be a procedure that has to be followed. An elementary procedure that is required, a mandatory procedure, is that a person should at least get a hearing. This issue first time cropped up in the famous case of Rajesh Agarwal, which was decided in the Hyderabad High Court. Then it came to the Supreme Court. Honorable the then Chief Justice Chandrachud and my Lord Justice Kohli delivered that judgment, which gave a big respite and held that it is critical that a person who's declared fraud is given personal hearing. So a safeguard was introduced, and that was a very balancing exercise to safeguard the interest of banks. The circular itself was under challenge, but the circular was upheld. So it was held that the banks have the power of following the procedure and declaring an account as fraud because it is important to safeguard public monies. But also a balance was struck with regard to rights of an individual to have a hearing, to have a say before it faces the consequences. Now, this judgment was of 2023, but unfortunately, many banks are still not following that mandate. And this is a classic example where the Bombay High Court now in the recent judgment has held the declaration of account as fraud by Canara Bank to be illegal simply because the natural justice had not been followed. No hearing was granted.
Point very well.
That's the sum and substance of the whole issue.
Point well. Thanks for the opening comment. I remember with Ma'am Ruby Ahuja, we did a show that time after the Rajesh Agarwal judgment. And in fact, you reminded me of that today, that we had taken it up in a big way. I want to ask you is that when courts step in on these consequential issues, is it a vote to investor confidence? I mean, thank God for our courts when they step in and adjudicate, and it's at the High Court level that such reliefs are now being given. Nice. You didn't have to go to Supreme Court. Could you analyze the situation of us? Why such judgments are a thumbs up to invest India? Because courts, we have been consistently saying, play a very important role in ensuring that people continue to invest in India because they get quick redressal whenever there is an overstep by the banks. When, as Mr. Agarwal also said, that it's not a simple case of fraud classification, a series of consequences follow. Over to you.
Thanks, Tarun. I'll just take 10 seconds and I'll say it's a pleasure to be on this panel, Justice Kohli. And I say this on behalf of my friend Mahesh also. It's our first show with you and we are very happy to be here.
Thank you so much.
Yes. And Tarun, to answer your question, I'll take from where Mahesh left. He said this circular is nothing but is an alarm. It's an alarm bell. So what our courts have said, they have said that you please ring an alarm bell, but do not ring a fake alarm bell. So that is why the courts have stepped in so that the circular is applicable. It will be used, but it will be used according to the system we believe in. Audio altrum partem or principle of natural justice of giving a party a right to be heard before putting any consequence, which is in a case like this, which has a cascading effect when you declare somebody as a defaulter. The court has stepped in to say that, look, we will protect you also. We understand we have to protect our banks, we have to protect our public money, and it's a valid circular. But investors should not come and see that, look, anybody can declare me a defaulter. My whole business, my whole credit line will be stopped. My whole business will be stopped. It has a reputational damage also to me. And some people are doing business worldwide. They do not want to have this on their shoulders of being a defaulter. That is why I think courts have come in, and you have rightly used the word, to strengthen the investor confidence. It's high, and courts are now doing it time and again. We have seen it in other branches of law, in arbitration, in insolvency. Fortunately, now courts and our judges do not take extreme stance one way or the other. That is why they are there. And because of the expertise they bring to the table, they want to come in and say that, look, we will always make sure that all parties are given equal opportunity. We have believed in that, right? From Menka Gandhi's case, we have believed in this, that everybody should be given an opportunity to being heard. This court has not done something very drastic. It has just followed what the system believes in, that you tell us, you give a party a right to be heard, a right to put forward the case. And if after that also you feel that a company or an entity or a bank account is a defaulter or a blacklisted, then so be it. So I think it's a very welcome step. I'm happy that the business world will treat it very well, and we are good to be in this space.
Point very well taken. I'll go to Justice Hema Kohli. Ma'am, you gave judgment on this issue long ago, and the court now has had to reiterate it because Canara Bank, in a sense, overstepped what it had to do and didn't give a hearing to this. So if you could analyze the whole situation and also comment on what Mr. Advocate Mahesh Agarwal and Ruby Singh Ahuja have said. Over to you, ma'am.
Let me start by thanking all of you for such a warm welcome. It's a pleasure to be on this program, and can see the popularity that Tarun has brought to it with touching on subjects across the board, civil or criminal. It is quite engaging. So the subject today is a matter of chance that it's a judgment in Rajesh Agarwal that was rendered with then Chief Justice Chandrachud and my own self. At that time, the purpose of nailing the whole thing was several cases from across the country were coming up to the Supreme Court, where courts had given different decisions. Mr. Agarwal just mentioned that the Rajesh Agarwal case was the one that had come from Telangana in 2020. Subsequently, in 21, another division bench of Telangana held otherwise. And then the Gujarat High Court also held otherwise. So there was a little difference of opinion. It was thought appropriate to settle all that issue by reiterating what has been the lifeblood of our jurisprudence, that principles of natural justice have to be read into anything, whether it is judicial or a quasi-judicial order, notification, or any kind of procedure. And that is what has been reiterated. And as Ruby said, it's been reiterated from the times of Menka Gandhi, MS Gill, and all of it. So it's not that we are saying something new when that judgment was rendered, but in the context of this fraud, that circular, that master circular issued by RBI, the import of that being that once that list is drawn of those who are treated as part of that circular, it is circulated by RBI to all other lenders. And that is what is killing. Because if those names are there, it puts others to notice that they will not be permitted to take borrow any amount or be treated as a honest borrower. That is what the impact is. So in the civil consequences, the criminal is, of course, that will go to CBI, they will open up an inquiry and all of it. But the civil is that actually would be like a civil death because you're blacklisted. That's a sum and substance of it. Of course, we are going to discuss it threadbare, and I'll go back to Tarun for that.
Yeah, thank you for that opening comment. Now I'll raise two issues. Advocate Mahesh Agarwal mentioned civil death. Now you interact, Mr. Agarwal, with a lot of promoters every day who put in not little amounts but billions of dollars in India. They all have taken loans for it. And there may be times that, there may be a bit of an issue or some allegation. How do you think the banks should treat it? A second, how do you think the courts have come up in this case? Justice Revati Mohan Dere and just Dr. Neena Gokhale, judge, they have stepped in and come to the rescue of this businessman. Many times courts don't have the time. Now Justice Hima Kohli, Justice Chandrachud gave this judgment many years ago, but still banks are sort of taking such steps. Do you think they should be sensitized, because India is looking to get billions of dollars of investments over the next few years as we go to become a $5 trillion economy? This sort of decision may sort of, bar it. Over to you.
See, it's very important to give confidence to the investors and the promoters. When they invest money, the intention is not to defraud people, but the business may go down for any reason. There could be some calamity, force majeure, some Supreme Court judgment which cancels coal mine, etc., because of which some losses occur. Now, there is a distinction between a default and a fraudulent default. What is happening today is that a bank feels that every default is fraudulent. And the circular has actually laid down detailed guidelines as to a difference between fraudulent transaction and non-fraudulent transaction. So the importance of natural justice is that a person is able to explain to the bank that if there's a default, it doesn't automatically mean it's fraudulent. There could be reasons because of which some loss has occurred and which has resulted into a fraud, a default. So what this judgment does is read an important aspect of liberty in the whole framework of the RBI circular. Otherwise, what happens is that every banker, moment there's a default, will issue a notice that so-and-so has become a fraud account, and the person suffers what we say a civil death. So an important aspect of a an opportunity is given to a person to explain that the default has happened for certain reasons, and there can be a remedy situation and not necessarily a fraud.
Point. This. Over to you. You're trying to add something more.
But what has happened now is that even after the judgment, an issue is still surviving, that before the judgment came, certain banks had registered FIRs based on declaration of fraud. Now, as a result of the judgment, that fraud declaration is gone. So person is no more a fraud, but the FIR is hanging. Now, some courts are taking a view that this FIR has to go because the basis was a fraud declaration. And some other courts are taking a view that FIR stands on its own. Now, this issue is now getting resolved again by another bench of the Supreme Court, and the hearing is going on and the judgment will be expected. But that is also an important issue which is surviving as of today.
Point very well taken. I'll take this to Ruby Singh Ahuja from Karanjawala and Company. Ruby, one thing I want to know from you, we discussed this threadbare during the Rajesh Agarwal judgment, but as we see, this problem still persists. Banks are still classifying without giving a hearing to a promoter. Could you sort of analyze how this could impact people investing in India? Will they start hedging and putting money abroad? Second, how important the role of not only the Bombay High Court, but high courts across the states becomes to nip this in the bud whenever the bank violates, because we see clearly that despite a Supreme Court judgment, this happens. Bombay High Court, of course, this, but there could be other high courts where these issues may be there. And if you don't get a hearing in time, then the promoter, as Mr. Agarwal says, faces civil death. Could you explain this a bit?
See, Tarun, to be fair to our high courts, frankly, they do follow the Supreme Court judgments as far as possible in letter and spirit, to be fair to all our high courts. That, judicial propriety is being followed in the country very well. But yes, there are cases where people are still, some bank will still, declare a defaulter without giving them an opportunity of being heard. And then you have to go to the court. I think the answer lies that the judiciary at the high court level, also with great respect, will have to be sensitized to the commercial needs of the society. As you know, you would have heard, I'm giving an example, like I think last week it came that one of the honorable judges said that, look, environment is important, but progress of the country is also very important. Infrastructure is very important. So I think the judges will have to be sensitized to this, that you need to bring a balance, and cases like this will have to be given importance. Before we go to the judiciary and put this onerous task on them to, say that, look, every order of like this should be treated on priority, fair enough, I agree. But I think banks should also be sensitized. They should be told that, look, there is a judgment, something has been declared now by the Supreme Court, it's law of the land. So please follow it. If I think it starts at the institutional level, it will become better. We do not have to bother the courts then. Unfortunately, what happens, it's not followed at the institutional level more than at the judiciary. If once it is, so what happens then? That is why you have the cases pile up. Sometimes priority hearings are not given to even if, when the courts want, also there are various circumstances which we all know. So I think the sensitization has to come to the people who are working in government organizations, to the institutions, to the officers, secretary level, who are told that, look, you will have to make sure that extreme decisions are not taken, which pulls away an investor from India. So I think this some sort of a campaign must start at the government level of educating. We have our judicial academies. There can be an academy like this also, so that, where you can see that people get the confidence that, yes, India means business. So we are not here just to be put from pillar to post. I don't have to file a case in the High Court, then I don't have to go to the Supreme Court. My job will be done according to the law laid down by the Supreme Court, by the officer at the window.
Point very well taken. And India means business is the right statement you made. In fact, I remember how popular the Rajesh Agarwal judgment was. I think it was SBI versus Rajesh Agarwal, and almost all businessmen in flights you met, at airports, wherever, and this judgments, I remember, was discussed to what kind of a large impact it will have on Indian business. And it was a thumbs up for corporate India, that you invest, the courts are behind you to protect you. Now the government is seeking billions of dollars of investment, but I want to now move to the middle promoter, which is, businessmen with 200-300-400 crore turnover. They are not rich to hire big lawyers, and when they face these kind of classifications, appealing to a high court and then getting relief may not be that easy. So do you think when the Supreme Court lays down the law or adjudicates, there should be some seriousness shown by the banks also? And your comment, over to you, ma'am.
You're putting the question to me, sir? Okay. Incidentally, I think there was an application for clarification of the judgment, whether it was prospective or retrospective, and it was made clear that the judgment itself doesn't need to be elaborated. And a reference was made to the conclusion to say that this is how it stands, to put a lid on any dispute about its prospectivity or retrospectivity. And fact of the matter is, and I think one must appreciate the fact that the Bombay High Court has dealt with the matter with reasonable dispatch, knowing that it is a covered matter. And the judgment you're discussing, the order that you're discussing, we'll call it an order because it's a brief order, simply says, in the context of the judgments rendered by the Supreme Court, the order passed by the bank in this case cannot be sustained. And that is the quickest way of delivering justice, in a manner of speaking, because what Ruby was saying a minute ago was that everybody should be made aware, and it takes so much of time sometimes for the matter to ripen and be heard. So what if that matter was put to notice, and after that the whole rigmarole of pleadings and everything took place? Perhaps the winner would have been the loser by the end of it, if I can use that term. In a good way and in a positive way, the Bombay High Court didn't go into details. It just referred to the fact that it's a settled law and there is nothing more to be said about it. And let's just get on with it, wash that, give them an opportunity of hearing. At the end of the day, what is audio ultimatum? That there is a notice, that there's an opportunity of hearing, and there is an order that is passed which is understandable by the party. Now, when we talk of an order, we are not talking of a judgment being passed by the banks or anything like that. Something which is basic, which is understandable, and which conveys the reasons why that order is being passed, which is what has been emphasized even in Rajesh Agarwal. Because at the end of the day, the party who's affected should know what exactly he did. If I will refer to the judgment, at some point, the stand taken by the banks was that the party concerned, the borrower, is part of that fraud audit that takes place because questions are put to the party. Information is gathered from the party, and then only is this assessment done. But we, in that judgment, felt that merely being part of that audit would not be treated as a hearing and an opportunity of hearing to the party, because end of the day, it was required that whatever assumptions that were drawn against the party on the basis of the documents furnished, and by the party we mean the borrower in such like cases, uh, the impacted party should understand that what weighed with them. They have to vocalize it in that notice and say this is what is persuading us to take it further, to be for us to take a view that the matter must be referred to CBI, and then the civil consequences of not lending. Now let's not forget, it's not just not lending or not being able to borrow. The reputation of that company is completely at stake. And if something like this happens, you can't retrieve it. Nobody will touch that particular company with a barge pole, knowing that it is the banking institutions and the financial institutions who have decided to back off from the party on the strength of the information circulated internally by the RBI. So though it's an internal process, the impact is completely external. And that is why it was imperative for the court to clarify that this is not how it can be done. Give the opportunity to the party, let him know what is wrong with his accounts, with his business, with his finances, and then take it further by saying, no, this is what we think. And we had also clarified that the principles of audio alterum partem do not apply in the case of where the banks propose to file an FIR. There is no such need for anybody to give an opportunity of hearing. That is a different course of action. It is only in such like cases where the civil consequences are as serious as what we have just discussed of not being able to borrow, not just the company, all the promoters. They're also barred. There is no funding that the promoters can claim. So there are serious issues that get that were highlighted in such like cases. And in all fairness, it is for the banks, for all FIs, to follow the judgment to the hilt and not have parties run to court ever so often with clarifications or with assuming that they will issue a notice and the party has to go through the whole rigmarole of accessing the first court, appellate court, and ultimately the Supreme Court for relief. By then, it would be absolutely a dead word. Nothing would survive in the case of such a company.
Justice Kohli, when you speak all this would be a sigh of relief and music to the ears of people who put in money in this country, because we all need judges who are sensitized to businessmen, and often we hear them complaining that they are not respected for the jobs they create in this country. But when someone like you comes in, steps and speaks on it, it is a vote of thumbs up that you invest in India. The courts are there to stand by you. That is something that we really appreciate. I'll go to Advocate Mahesh Agarwal. Mr. Agarwal, you said civil death, and of course, the impact would also be on the employees that work, because with no money, nobody can pay salaries. You have been a part of this system for long enough. Could you just put this in perspective, the role played by the courts, what banks are doing, and what is the way forward to ensure that India keeps getting investment money? Because let me share this with you, and you know it better than me, that such judgments are discussed in London, in New York, and other countries from where money flows into India. That is why such commercial judgments are important. All those GCs, all those promoters look very closely at these things and they discuss it. Over to you, if you could give us a holistic picture.
The RBI circular, as I said, had a very important purpose. And the Supreme Court has stepped in to protect the rights of the investors by breathing into it a concept of natural justice. So that definitely gives a lot of confidence to any investor that an arbitrary action will not be taken. But unfortunately, what we are seeing even now, after the judgment, is that many banks, maybe because of pressure or whatever reason, are just giving lip service to the judgment that they have to give a notice and take a decision fast. Now, what needs to